我哋有足夠嘅法定人數咧，亦都係夠鐘。
Members, we have the quorum, and this is the appointed time, and I call to order this meeting, and let's invite the administration in. Members, the meeting was originally scheduled for the 6th of November 2017, but we had the crop meeting on that day, and two-thirds of the members were required to attend that meeting, so I cancelled the last meeting scheduled. And I'd like to apologize to all the members, staff of the Secretariat and the administration for cancelling that meeting at the last minute. And attending today's meeting, we have from the administration, Ms. Mimi Lee, Deputy Secretary for Security, Ms. Iris Lee, PAS for Security, Mr. Percy Leung, Assistant Secretary, Ms. Anthea Lee, Deputy Principal Government Counsel from the Department of Justice, Ms. Carmen Chan, Senior Government Counsel from the Department of Justice, and also Mr. Gary Lee, also Government Counsel from the DOJ. We had the first meeting, and then on the 10th of October, we had a public hearing. After these two meetings, the Secretariat issued altogether 3 letters to the administration, raising some issues to the administration on our behalf, and the administration has also prepared a very detailed response to the issues raised by members, and we can refer to these 3 letters: CB bracket CB bracket 2164/1617 bracket 02. And the administration's response is CB bracket 2165/1718 bracket 01 and bracket 02. And also 2 other letters, CB bracket 268/1718 bracket 01, and the government's response, CB bracket 2333/1718 bracket 01. And there is also another paper we can refer to in a minute. I think these papers have responded in detail issues raised by members. I'd like to see if members have any follow-up questions from these papers. And if you have a question, please raise your hand. 5 minutes each. Mr. James Toll. Perhaps for the benefit of the administration, I should give some explanation. I don't think the administration understood my question. Why the difference between terrorism and a terrorist act? For example, in the electrical brief, in your electrical brief, page 3 in Chinese, and please also cite the paper number. Mr. James Toll. Electrical brief is the brief forwarded to members before the Bills Committee has been formed, but the administration has also included the same in CB bracket 22164 in the annex, and that's just the electrical brief. I am reading from the Chinese version. It says on page 3 that our key proposals are outlined below. And then ABC, that's page 3 in the English version. So the bill is actually drawn up on this basis. Paragraph 5A, to prohibit anyone from leaving Hong Kong to participate in terrorist acts. All right? Participation in terrorist acts. And then the phrase that follows, the provision or receiving of terrorist training. In other words, it's not receiving of terrorist acts training, but receiving of terrorist training. What about the second paragraph of footnote 7 of the paper? There is a definition of terrorist act, but no definition for terrorism itself. So let's say if you participate in terrorist acts, then you are participating in Section 2 of the ordinance, action that causes serious violence against a person or serious damage to property. So for terrorist act itself, it's well defined. And also point B, another prohibition to prohibit any person from providing, collecting property, etc., from participation in terrorist acts. So the property is used in participation of terrorist acts, not terrorism. So my concern actually relates to the second part of 5A. Why not receiving of terrorist act training instead of receiving terrorist training? Because you need to define what terrorism is, and it is much more difficult. Now, you have argued with me on a number of occasions why we should include the term terrorism or 行為 in Chinese. And terrorism may refer to some kind of ideology, whereas terrorist acts refer to some physical acts such as assault. Terrorism as an ideology is hard to define. So if there is no definition, and if you receive terrorist training, it means that the administration will be given too much power, and everybody will be subject to the provision of prohibition. Perhaps you might be receiving some kind of training, and then you will accuse me of receiving terrorist training. On page 2 of the paper, I think the administration has already responded to this point. I don't think Mr. To is happy with the answer. Perhaps DS can take us through the answer again. I think what is more important is to consider the ultimate proposal of the bill. In fact, in Chinese, the meaning of the provision is already provision or receiving of terrorist act training, perpetration, planning, or preparation of, or participation in terrorist acts, not terrorism. And the relevant explanation has been given in CB bracket 2164/1617 bracket 02 in paragraphs 2 and 3. Deputy Secretary, perhaps you can also explain once again this point about the terrorist acts referred to by Mr. James To. It's also in the Blue Bill. Perhaps you can point that out in the Blue Bill for the benefit of Mr. To, so that in due course when we discuss that it would be clearer. Is under Part 3C, 11J, about definition or interpretation of Part 3C, and then specified purpose in A and B, we use terrorist acts instead of terrorism. So perhaps I can read it in greater detail. I have just been reading the electrical brief. So that means in A, you're suggesting that provision or receiving of terrorist act training, and in the electrical brief you have missed out the words. Is that the case? The electrical brief is rather succinct. We're still in the process of incorporating views, but in fact the key to this provision is terrorist acts, not just, or terrorist acts training. I think the Blue Bill's version is clearer. I can wait for another round. All right, I will allow another member to ask the questions first, and then perhaps if Mr. A. Chan, you find the relevant paragraph, you can remind Mr. James Ho. Is there another member who wish to ask questions? If not, then go ahead, Mr. James Ho. Well, this is the electoral brief for this bill, right? Am I right? This is not any previous papers issued. This is about the bill. So I have read the electoral brief. If the act being prohibited is any permanent resident leaving Hong Kong for the purpose of receiving or provision of terrorist training, then sorry, I haven't checked it against the blue bill.
So I just want to make clear whether the term act should be included, because terrorist training is different from terrorist act training. Deputy Secretary, any supplement? Not especially. I agree with Mr. To, but I have to emphasize once again that the blue bill, that we should focus on the blue bill. All right, I would allow Mr. Ray Chan to first ask his question. Yes, I'll follow up on Mr. To's question. The blue bill, as pointed out by the Deputy Secretary, has included the term act. But if you can look at that long title, it said it would repeal after to implement certain and before, and to provide to substitute recommendations of the FATF to further implement a decision of the Security Council of the United Nations in its resolution 2178 of 24th of September 2014 relating to the prevention of travel for the purpose of terrorist acts or terrorist training. So also, for the long title, can you also include the term terrorist act training instead of only terrorist training? Deputy Secretary. Oh yes, our purpose is actually referring to terrorist act training, and that has already been made clear under 3C 11J, because we have set out terrorist act training. We have put it that only by going abroad to engage in terrorist act would be mean for the specified purpose. Why I understand Mr. Chan's concern, but when we are executing and implementing the bill, then we would have to defer to Part 3C. As to the long title, I think we need to reconsider. Well, because we are still not at the clause-by-clause scrutiny, so I think we can still consider these comments. Mr. Chan. All right, so the proposal is to prohibit any Hong Kong permanent resident from leaving or with the intention to leave for the purpose of such terrorist act training. Let's say a person has already left Hong Kong and now he wants to re-enter Hong Kong, and if you already know of this resident coming home, yet he has engaged in certain act, how can you prohibit this person from returning to Hong Kong? Because I remember I did ask the secretary a couple of days ago, a Hong Kong PR or anybody because you were talking about persons with the license to enter Hong Kong, or maybe some people such as pilots who are eligible to enter Hong Kong. Well, let's say this person left Hong Kong and you found out that he is engaged in such activity. Is there something you can prohibit this person from re-entering Hong Kong? I think I asked something about that last time as well, Deputy Secretary. Well, Chairman, if this person is a Hong Kong PR and he did go abroad Well, and I'm sure if he's trying to return to Hong Kong, somebody will be waiting for this person at the border. This is actually in violation of the law, even if he engages in such activity outside of Hong Kong, and that person will be arrested when he tries to enter Hong Kong. Well, you prohibit this person from leaving Hong Kong if you know of this purpose. Or does that include arresting this person? Because, of course, once a person is arrested, then he will not be able to leave Hong Kong. I think this would include arrest, right? Because then you would be able to prohibit this person from leaving Hong Kong once he is arrested, right? Well, not exactly. When a person has not engaged in terrorist act, he may be communicating with someone in Syria or other countries. He has a purpose. His purpose is to intend to learn or to receive training to come, and then after learning this knowledge he would come back to Hong Kong to violate the law. We don't have anything to prohibit this right now. But then if once we amend the law and he has this specified purpose which we have proof of, we'll be able to arrest and prosecute this person. Mr. Chen? Well, then you have to consider all the different scenarios. Let's say this person receives training outside of Hong Kong. Or maybe he just sits for a briefing and he did not receive any training. Can you still arrest this person at the border? Deputy Secretary. I think anti-terrorist measures are usually adopted with an informed news, and if there is proof to show that this person's intention to go abroad is to meet with certain organizations and to receive certain training, then there would be enough proof to arrest him under the law. Mr. Chen, I have read the paper CB-2-165/1617-02. I think the Secretary has reminded me that there was a mention of what you asked about. I think because there was an extraterritorial application, I think it's under paragraph 33. And if you think there is a need, then we can follow up with this extraterritorial application later on. Mr. Hu Chi-wei, 3 minutes. Thank you. I'd also like to follow up on the definition under Terrorist Act. In paragraph 2, it points out that to talk to on maybe on a religious basis or financing the travel of such persons. So what kind of people or group are we talking about? Do we have a list of groups or people that would, or maybe if they engage in any act because of religious acts, would they also fall under this regulation? I think we've asked this question many times, Deputy Secretary. The United Nations Anti-Terrorism Measures Ordinance refers to terrorist acts of great So there is no definition of forcing countries to comply. Whether it be forcing Hong Kong or United Nations, we are talking about a serious violent acts or acts that harm serious or that cause serious damage. The damage must be submitted to proof, and the intention must also be of a major impact. We're not talking about just an individual or a small group of people only. In 2002, when this was discussed, it was very thorough, and so because terrorist is acts are global. If we deviate too far away from other countries, then it will be difficult for us to enforce the law. Therefore, we want to ensure that the definition will be similar to the definitions of other countries. Chairman, so can I take it to understand that B here does not make too many specifications, but you're only looking at the action and the intention of the action, of whether there is a specific action to cause this threat. So whether a person would be arrested, we would need to look into the situation under 1. Deputy Secretary, I can say that the person we're talking about that the action carried out or the threat being made would have the effect of serious damage. And then it would partially comply with these definitions, because we'll need to look at the actions to see whether this action is threatening SAR government or some organizations. So I think you need to comply with both. I'm not very clear. I'm more concerned with, let's say I have an intention I've been thinking of an intention, but it has not been taken out in action. So would I be violating the law? Well, intention, of course, it would be something that a person is thinking about. Or maybe the action has not been carried out. We would need to look at the individual cases to see whether there is any proof that a person has such an intent, and would this intent be enough to prosecute this person. But we have to be very sure, because terrorist act is a very serious violation and the threshold is quite high. CP 265 in the paper of the government's response, there was a very clear definition of terrorist. Of course, there's also terrorist act, terrorist associate, terrorist property. Everything is listed out very clearly in this paper. CB2 165/1718(02). I'm sorry, can you repeat? CB2 165/1718(02). Please refer to this paper. Oh, so there is a definition of terrorist act. Where? I'm sorry, terrorist act, not terrorist. Mr. Ma Fong Kwok. Thank you, Chairman. I also have a couple of questions. The first one is this bill will prohibit a person from leaving or going on board with a conveyance with the intent to leave Hong Kong or a place outside Hong Kong for the purpose of this act. So how do we know? How do we know whether a person is transiting in another country to reach a third country? Because we don't have the jurisdiction in the country or a place outside Hong Kong.
Second question. Just now, Chairman referred to the paper which defines the Terrorist Act according to Section 2 of the UNATMO. There are several bullet points. I'd like to ask about A2B. That is, if the threat is made for the purpose of advancing a political, religious, or ideological cause. I'd like to have an idea of the administration's interpretation of this phrase, because other points are easy to understand: causing serious violence against a person, damage to property, serious risk to health, or seriously interfering with disrupting an electronic system, essential service, etc. For A2A, it says intended to compel the government or an international organization or to intimidate the public or a section of the public. Frankly, about intimidating the public, during the Occupy Central movement 2 years ago, many members experienced the same kind of intimidation. When we walked out of the electrical complex, we were subject to intimidation. People shouted intimidating remarks at us. So how do we define this? How do we enforce the law outside the territory? Well, we have thought about this point in the bill. For a Hong Kong permanent resident leaving Hong Kong to another country to take part in the Holy War or to receive training for the Holy War, then the person will be breaking the law. This is clear. At the same time, if the Hong Kong permanent resident is now already in Canada, and then if the permanent resident travels from Canada to Syria to take part in the Holy War or to receive training, after this bill is passed, this person will also be against the law, because we have the extraterritorial application of the law. That means for this Hong Kong permanent residents, even if the permanent resident isn't in his own country, even if he participates in an act against the law, causing harm to the country, then he will still be breaking the law. What we do is we collect intelligence. We're aware of the prospective acts of the person concerned, and we're going to exchange information with the country in question, and through our international cooperation mechanism, the law enforcement authorities will be waiting for the person on the other side. And even if the mechanism fails, once the permanent resident returns to Hong Kong at the border checkpoint, since the person would have been put on the checklist, he will be arrested right away. Mr. Ma Fong Kwok asked another question. Made for the purpose of advancing a political, religious, or ideological cause. What is the definition? And I think this is a similar question put just now. First of all, we need to make sure that this person reasonably knows that his act would be causing serious damage to property or seriously interfering with an essential service, etc. So this person must be aware of the consequence of his acts, and then he must have the intention to compel the government or intimidate the public for the purpose of advancing, for example, the Islamic religion or any ideological cause. Well, we do not have any definition on a political, religious, or ideological cause because we find it difficult to provide a legal definition in the law. We have mulled over Mr. Ma Fung Kwok's point, and that is why we have kept the provision so written. And we have not revised the definition of terrorist act in this exercise either, because we believe that we are in line with the international definition. I want to supplement because 2 years ago, well, in the incident that I came across, according to media reports, those people concerned received training abroad. And then, since it was not against the law in the other jurisdiction, then the person was not breaking the law. But the person actually committed acts of causing disruption to social order and stirring up public anger by spreading gossips, etc. And also, those persons also went, instead of direct flight, a number of transits through other countries. Well, to my understanding, does it mean that the person will still be liable if the bill is passed? Let me supplement. We need to consider the scope of terrorist acts. As I mentioned just now, there should be an intention to cause serious damage, and the act must also be linked to the intention to, say, compel the government or intimidate the public. And it may be, well, if evidence is sufficient, we may invoke the ordinance. Otherwise, we cannot just arrest a person by accusing without any ground that a person is receiving training elsewhere, etc. Mr. James Toll. Mr. Ma Fung Kwok is a member of this council. He is also an NPC delegate. Well, as we scrutinize this bill, which is the UN ATM Amendment Bill 2017, he is trying to hint something, and I stand to be corrected. Well, he can clarify. All right, I'll give him time to clarify. As a member of this council and a member of the NPC, if he is hinting that Joshua Wong went to U.S. for the purpose of receiving terrorist act training, then let's imagine. We should consider why our young people are so concerned about this bill, why we have received so many written submissions on this bill. Well, I think it's common ground. If we're talking about ISIS training, then we do not have any strong views on that. But I think what we are worried about is exactly happening now. At least this is the concern of our young people. And Mr. Ma is trying to hint something. And I think as a result, we need to be extra careful in considering whether there is any hidden or hazard in the bill. Now, Mr. Wu Chiwai cited a paragraph for terrorist act. Well, in the extreme scenario, for example, if you go to another jurisdiction, you want to be a professional hitman. if you want to be a hitman and make a living, and that may not have anything to do with terrorism. You may receive a bounty, and then you may learn how to operate a rifle, etc. The point is, for the Roman 2, intend to compel the government, etc., you do not have this intention. So your act is not regarded as a terrorist act. It's just a criminal act in the ordinary sense. It's not a terrorist act because you're not doing it for advancing certain ideological cause. But here's the problem. And may I be frank, I'm not talking about Joshua Wong. And I think Mr. Ma can clarify in a moment if that's not what he means. For example, there is a terrorist organization regarded by the Central People's Government as one, but not Turkey. But now with better international relations, there may be more restrictions. For example, there may be the resistance army which would like to siege the governor's house, etc. And this.
或者佢去美國麻省 ，OK， 咁咧可能咧。
Well, let's say for the organization, if somebody from that organization goes to Massachusetts, then China may regard the person as a terrorist. That may regard that as terrorist training, and then we may be asked to prohibit any issuance of passports to or visas to the persons so going to Massachusetts for training, for another journey to Turkey, etc. If you extend this application to other areas, then it will be very controversial. DS. After the ordinance has taken effect, so far, I'm happy to report that we have not really invoked this section to suggest that somebody has committed a terrorist act and hence committing a crime. This is good news because in terms of terrorists or terrorist activities, our risk level remains at medium level. And also, it has to do with whether it falls within the definition of a terrorist act.
如果係有人同呢個組織聯繫咧，好明顯。咁呢個咧
And it's defined by the UN Security Council that it is a terrorist organization. Now, if somebody travels to Istanbul for the scenery, for sightseeing, then that's another matter. If the person has no association with the terrorist organization, then the person will not be wrongly accused, because it is a serious allegation to suggest that the act is a terrorist act. So it depends on whether the act is a serious terrorist act which causes serious violence against a person, serious damage to property, etc. So the word serious is key, and also seriously interfering with or serious disrupting an electronic system. A minor disruption may not count. You need to meet all the criteria. But coming back to my point, with the spread of terrorism around the world, other jurisdictions are tightening up their laws, and we're keeping a close eye on these matters. In this exercise of amending the ordinance, we have not revised the definition of terrorist act because we have never invoked this section in the past. You may say that we are preempting for things. We need to consider that so many years ago, in 2009, the United Nations already did something about the racism, extreme racism. They have already been included under terrorist acts, but not in the case of Hong Kong.
Because we're talking about different ethnicities, Islamic groups, and therefore the terrorist act should be defined that if there is an extreme racial act, then it may be called a terrorist act. But we didn't think that there is a need to revise the definition this time. But of course, we cannot rule out the possibility that with the changing times and if there is some unexpected happenings in Hong Kong, then we might need to make an amendment. But Mr. To, be rest assured, our threshold is very high right now. Thank you. Mr. Ma indicated that he would like to clarify. Would you like to speak now? Thank you, Chairman. Mr. James told and mentioned my name a couple of times, and my question to the government. My question was actually very simple. Since we're now looking into amending the bill, I would like to have a better understanding of the bill. And my questions are related to some recent occurrence in Hong Kong. And since we're amending the bill, this is something I must do. It is my responsibility. We want to make clear to the members of the public that such concerns could be allayed. I don't quite understand Mr. To's saying that I'm trying to tighten up the bill. I just want to clarify on how we can identify terrorism. I don't know why Mr. To is being overly sensitive. I'm not trying to target anyone. I just want to make clear the bill. Thank you. No, thank you. All right, everyone is clear. Next, we have Mr. Ray Chen. Thank you, Chairman. Paragraph 33 in the new paper talked about the extraterritorial application. This paragraph is very simple, that this bill, if passed, can be achieved by seeking assistance through international cooperation is provided for under the two ordinances. Have these two ordinances been given to us? If not, can you provide further information on this later on? Back to Mr. Ma's question on 11K on people from Hong Kong going to another country through a place outside of Hong Kong. If I know that you already have intelligence about a certain person, then you would prohibit this person from leaving Hong Kong. This is very clear. But let's say this person did not commence his trip from Hong Kong. This person left from Europe. Well, if you have the intelligence, then you can arrest a person when he arrives Hong Kong. But can you already do that without the new amendment? because even for 11K, you're just talking about a person who has already commenced a trip. But if the person has already begun the trip or have started receiving training, then that's already a violation of the law. And if this person was caught outside of Hong Kong, then he might already be arrested outside of Hong Kong. So 11K2 about a PR not leaving the HKSAR or placed outside for a foreign state of a specified purpose is why do you need to put it like this? All right, the first question relating to further information, the administration can provide it afterwards. Deputy Secretary. Well, yes. If a person leaves from another country to a third country for a specified purpose, right now we are providing sort of like a one-stop bill. If a person goes abroad with the intention of participating in terrorist act or to engage in terrorist act training, then this is in violation of the law. If a person is already outside of Hong Kong and he leaves for a foreign state with this purpose or intention, that is also a violation. But as to how we can arrest this person, then it will be a different matter. We can provide you with the regulations, but we can also learn from intelligence from Interpol and other related organizations to see whether any action could be taken in the foreign state. Anti-terrorism is done worldwide, and we are all closely connected. Well, unless a person never returns to Hong Kong, otherwise, I'm sure enforcement officers would be waiting for this person to come back if we know, and this person will be arrested immediately to ensure that no harm would be done to Hong Kong. But if you do not pass this amendment, then this would not constitute a criminal offense and will not be able to arrest a person. Well, yes, I understand. Let's say this person already left Hong Kong and he has already received a training. Even without the amendment, you can still arrest this person. I'm sorry, can you repeat the question? I'm sorry. So this 11K is prohibiting this person for leaving Hong Kong. But let's say this act has already been done in a foreign state, and when he returns to Hong Kong and you arrest him, even without the EU amendment, you will be able to arrest him anyways, right? No. You are not able to arrest him under the current regulations. Yes, we can prohibit him from leaving, but let's say he's already in a foreign state. He's already intending or to engage in violent in terrorist act. We cannot arrest him as with the current legislation. Oh, I understand. Thank you, Mr. Wu Chi-wei. Thank you, Chairman. I want to make clear another point. We don't have a strong definition of terrorism. But each country may have different views on different acts. Or maybe I should put it in a simple manner. On the mainland, Falun Gong is considered an illegal practice. Now, under this background, with our current legislation, would that act, well, because maybe that act is not under anything in A to F, but because the mainland has already defined this sort of practice as terrorism, a Hong Kong PR might practice Falun Gong and may be prosecuted because of this. Deputy Secretary, I would like to point out that other than the definition of terrorism, there is a very important definition, which is terrorist associate, and terrorist property definitions. These are very important. For the definition of terrorist, we use one definition, which is a person who commits, well, let's say that before Bin Laden was killed, that is a person. A terrorist means a specific person. Under Section 5, the CE can apply to specify that a person is a terrorist or a terrorist associate. We have never used this before. Let's say Mr. X. Has Mr. X done anything under the definition of terrorist? We have never used this Section 5 before. But we have drawn reference from other countries, and terrorism causes serious damage. We are very careful in enforcement because this is very serious allegations. Of course, we would look at the act of a person. We will also need to see whether this person is connected to terrorist organizations. What do you mean by a terrorist or terrorist associate? We have definitions here, so they're all intertwined. We don't want to blame innocent people. Therefore, we will need to look at all the definitions. So if a person says that another person is a terrorist, then it doesn't mean anything. You will still need to go back to Section 2 of TMO, and then our CE would need to make an application to the UN to set out under United Nations. Yes. Well, if you're talking about the CE raising this in court, and even if the person is not defined as a terrorist, then it was very serious allegation. But don't worry, we consider this very prudently. And if we are to adopt this second mechanism, then it's not unilateral. You can invite the person who is who might be a terrorist to defend himself. And there's also a compensation mechanism in case we pointed out the wrong person. But usually, as of today, a Hong Kong SAR government still relies on the first mechanism. Mr. James Toh, in the LegCo brief, Chairman, I see that receiving terrorist training. Well, there's a receiving terrorist act training. The term act is included. So I'm sorry. I see that the term act is also included. But then you also, well, I'm not trying to go for the clause by clause scrutiny right now. I just want to understand that would the inclusion of the word say that because you talk about training related to terrorist act, because Mr. Hu Chi-wei has already asked about A plus B. One is the act and B is intention or political purpose. So we understand many years ago we thought through this very clearly. But now you're now prohibiting actions by using this. You say, oh, you're going over abroad for travel for the purpose of terrorist act. I would also ask a question on CE going to court, but that would be later. Why would you add in the blue bill the term related? Well, electrical brief is not wrong, because if you add the term related, that means that you are trying to provision or receiving of terrorist training. Or perhaps you can go back and think about it. Because, this seems to be what we have been talking about earlier. With the term in relation to. Thank you, Chairman. When we considered the ordinance, we also drew reference from similar ordinances in other countries. There is a quite important point here which Mr. To has mentioned. If we use terrorist act training, then it would give rise to Mr. To's concern that maybe attending a lecture might constitute a terrorist act training. There is something I forgot to say right now which is very important. In 2178 resolution under United Nations Security Council, in paragraph 6, they also use the term terrorist act training. They say if you are purpose of perpetration, planning or preparation of or participation in terrorist acts or provision or receiving of terrorist training. Yes, I see that. We agree with Mr. To that if you put it like that, then it would cause fear. So therefore, we changed it to act. We believe that the term act is clear. But then, what do you mean by terrorist act? Well, many years ago, there was a saline gas in the train in Japan, and in the 70s and 80s, there were many plane hijacks. So those cause serious damage. So of course, those were called terrorist attacks. But then nowadays, it's usually actions of an individual. And they're usually lone actions. So we don't know what's going to happen. A person might just drive a car onto the pavement at any time. So what kind of training would be considered as terrorist act training? There may be many discussions on that. In Australia, there is a Criminal Code Act 101.2. Well, it wasn't amended in 1995. It was amended at a later date. But then it said the training is connected with preparation for the engagement of a person in or assistance in terrorist act.
It's connected with, in our view, would provide sufficient breadth and flexibility for Hong Kong. But the most important thing is whether training will lead to a serious consequence or serious act in paragraph 2. And we would like to follow the Resolution 217's spirit. At the same time, we need to have sufficient room and flexibility. Then I need to think about it very carefully, because in Australia, there is, something similar. You can give me a written reply. Tell us what's the practice in another jurisdiction. And I'd like to thank you for being frank. You have told me about your thinking process. You have not told me so at the outset, but still, you have addressed my concerns. And I agree with the UN resolution's principles. Of course, we need to uphold the principle, but we don't want to lead to unnecessary concern in the public. And I think it's very refined. So please write it out. Let me think about it, especially when you're referring to another jurisdiction. That's the case for Australia. I don't know whether you have made reference to other jurisdictions. Well, since you have drawn up the bill, you, of course, would look for examples that supports your case. Using Australia as an example, they have already enacted the piece of legislation. I would like to know their thinking. Why some have not been covered? Is it because they can't be covered? And that is why they use the phrase connected with. So please give me some information for my reference. No problem. Next, Mr. Rim Chan. Thank you, Chairman. I'd like to follow up on the question of the definition of a terrorist. In previous meetings, in previous government papers, I think they already explained that the definition follows the UN Security Council's definition, and also another point that the chief executive could make an order. I understand that at this point, because the terrorist activities may change from time to time, and the list may not be updated to suit the needs of every country. And we do have a mechanism which allows the court to grant leave. And still, I'm concerned. When we met with Mr. Wang Shiman, he said that when it comes to national security, there is only one system, no two systems. One country should override two systems. In other words, if in the eyes of the court, national security is different from the security in Hong Kong, then how should we make the decision? I think I am speaking on behalf of the public when it comes to the concern. We have one country, two systems, but the mainland's list may differ from the UN's list. I have never invoked Section 5, you may say that. But ultimately, will the court be able to withstand this suggestion of two systems overriding one country, or one country overriding two systems? Let me say at the outset that when the court, the ordinance has taken effect for more than a decade, and the court has not ever invoked this mechanism. But subject to Section 5, the chief executive may apply to the court for an order, and then as the court procedure will be initiated, it should be regarded as a civil procedures, and then the court can only be satisfied on the balance of probabilities before an order is issued. The court will first of all consider the applicant or the subject in question, all the relevant acts, whether the person might cause serious harm or damage to Hong Kong, and more importantly, whether the acts engaged by the person falls within the definition of a terrorist act in Section 2. So to respond to Mr. Chan's question, we have one country, two systems in Hong Kong. We have a fully independent judicial system. Our understanding is that the judiciary or the court will preside over the matter independently and also refer to the provisions in the ordinance in making a decision. And as I mentioned just now, the persons involved may make representation, and after the order is issued, it will be gazetted, and if the person is wronged, there is another mechanism for compensation to be made out. So we have checks and balances. Chairman, I won't dwell on what happens in the court. Let's just see what happens. Let's take a look at the beginning of this procedure. The chief executive may apply for an order to be issued. What about this part of the procedure? Previously, I asked the immigration department about barring somebody from entering Hong Kong. And then I asked whether there is this procedure. There will be an order from the Beijing government, and then the immigration department will execute this order. Well, say if this chief executive may apply to the court for an order under Section 5, then will it be initiated on the order of the Beijing government? I don't see such wording in this ordinance. The chief executive may apply to the court for an order to specify 3 things. That is, a person as a terrorist, or a person as a terrorist associate, or a property as terrorist property. These 3 are clearly defined in the ordinance, namely terrorist, terrorist associate, and terrorist property. And then it will be up to the court to make this decision. So a follow-up question. The chief executive may apply to the court for an order. So that means the chief executive may not just arbitrarily make this decision. Usually we go to the head of the bureau. Perhaps the security bureau will advise the chief executive to apply for an order. The section doesn't specify what happens before the chief executive applies to the court for an order, but the responsibility lies with the chief executive as the head of the government. It is a very important decision to be made. So we need to find the official in the highest rank to make this application. I wait for more information to be given first. You say that there are other jurisdictions in your examples, but perhaps you can also include this in your written reply. You have the lone wolf attacks and also trucks ramming into crowds. These are very serious incidents. So it falls within, say, point A, violence against a person for advancing an ideological cause. Then it is already a kind of terrorist act. Why would you say connected with? You may choose not to answer now. Yes, we have lone wolf attacks, but that refers to the act. And I'm even more concerned about trucks ramming into crowds. There may be training in another jurisdiction on how a truck should be rammed into the crowd and how many you should kill. Perhaps you need to learn about a certain way of driving, and this is even more alarming for arms and ammunitions. Well, the former honorable member Zhu Yaolun, he is very fond of this as a recreational activity. Well, we have terrorists operating bombs, arms, rivals, but lone wolf attacks, ramming trucks into crowds, these are different matters. Perhaps you should consider this. This may not be the best example. It's very straightforward. But there may also be other less obvious examples that you have gone through. Let me ask this first. On the 3rd of November, the legal advisor wrote to you, and then you gave a response. That is paper number 333. And I want to make sure there is no misunderstanding here. The answer is quite technical, responding to the issues raised by the legal advisor. Perhaps let me ask about the legal advisor's question first, about the originator. What is the focus? Is it that you're concerned that you're concerned that this bill falls outside the scope of the UNHCR's resolution? Perhaps the legal advisor can clarify this point.
Well, the paper actually relates to 11K. You would see that in 11K, whether it be subsection 1 or subsection 2, the focus is on Hong Kong permanent resident. Even for a non-permanent resident, even if this person engages in all these acts, then they will not be included under 11K. Therefore, we want the administration to clarify. The administration said they want to adhere to the spirit of UNATMO because there were terms used in nationalities in UN, and therefore 11K is to ensure that it will meet with the resolutions under the UN. We find it very strange because we don't see under UNATMO that it is such a narrow scope that it only refer to HKPR. And if you choose to interpret UNATMO this way, have they considered Basic Law Sections 24 and 25 that Hong Kong residents include both Hong Kong permanent residents and Hong Kong non-permanent residents? Well, so simply put, it is not broad enough, right, to fulfill with the UN responsibility. No, what I'm asking is whether this exceeds the scope, but you are saying that it is a very narrow scope. Oh, can you allow her to finish? We have never said that the government scope is narrow or broad. We just see that there is a discrepancy between our bill here and UNATMO. Therefore, we want to make clear why there is such a difference and how it can really have this legitimate aim. So therefore, we want the administration to share with us why they set up 11K and whether they have sought legal advice from the judiciary and to see whether it can really comply with this legitimate aim. I think colleagues will remember that when we invited deputations to come up here, there was also a mention that why it only include HKPRs. Deputy Secretary. Well, I think we have addressed this question a few times in writing. 2178 focus is on nationals. Of course, it can also include other people, but we see in other legislations that the ambit will be on nationals and other residents. We really need to look at definition because we don't have a definition of nationality. Well, this is very important to Hong Kong because we're talking about people who live in Hong Kong. They treat Hong Kong as their home. This is a place where they come back to. So if you look at the expatriation of terrorist ordinance and also on other ordinances, we are trying to narrow the scope. But of course, you will see that this bill has been amended twice since 2012. This is the third time. Terrorist acts differ with the times, but we do have grounds for this. Well, we can make reference with terrorist acts made in Britain or in other countries. But because we have not witnessed some of the serious terrorist acts in other countries, we did not have too narrow a scope. We ultimately want to achieve a balance, Mr. To. Well, you talk about, the entire journey in writing up this new section. This is only a preventive legislation to ensure that these people who will engage in such acts will be prohibited from leaving Hong Kong. Well, we want to prevent these people from engaging in these activities before they leave Hong Kong. So this is how this new section came about. The legal advisor mentioned other people. We have sought legal advice. And this was something that the central government has asked us to do in 2014. Of course, we don't have nationals or status nationality, so therefore we only used HKPRs. All right. I will wait for the next round. Mr. Ray Chen. Thank you, Chairman. Or for those who intend to engage in terrorist act, or let's say journalists or war journalists, or maybe some journalists would try to work undercover and attend such training. Well, don't deviate from the topic. Or maybe they want to do academic research. Maybe some scholars may want to do some research. Would these people be affected by this legislation? Deputy Secretary, we have a definition of purpose or intended purpose or specified purpose. Well, for a journalists, you will not engage in an act. They are not going to do it. Well, let's say they are perpetrating in an act or more than one act of training. I'm sure a journalist wouldn't do that. And they're not providing any training or the provision or receiving of training. Well, a journalist wouldn't do that as well. For the specified purposes, we're talking about a sort of like a continuous actions on perpetration, planning, or preparation or participation in one or more terrorist acts. Let me give you an example. 911. The planes that rammed into the two towers. The two pilots or the hijackers learned to pilot a plane specifically for this purpose. Maybe we can see through emails the entire connection. Or maybe they visit a mosque every day. They communicate with each other in writing. And those hijackers went to learn piloting just because for this purpose. Then you will be able to see that they have a specified purpose. Well, from 911 to 1, you have seen serious consequences from this act. We don't want anything like this happening in Hong Kong. So now the United Nations have given the order that all countries need to take preventive measures. We, of course, are under the country China. Well, you can't prohibit people from taking classes or from learning. So we have to set out certain purposes. So this was our thinking. Mr. To, your turn again. Well, let me follow up with this point first. Otherwise, I would forget. Well, we understand that journalists who go for interviews, of course, would not violate the legislation. But maybe some journalists would not want to understand this in depth. They may want to have an exclusive. And so they would try to work undercover. Or it would be very difficult for you to clarify. Of course, they can show you their journalist pass and say that they just want to make an exclusive report. But I don't know whether they can really explain themselves. Well, you can only prohibit them because, on the surface, it would seem that they have an intended purpose. But then maybe, they would tell you later on that, they're just doing what their boss asked. Well, of course, you can still prohibit them from leaving Hong Kong. Or anyways.
Well, if you look at the electoral brief again, and I'm following up on the legal advisor's question. The legal advisor's question is, and if we go back to page 3 of the electoral brief, first, to prohibit any Hong Kong permanent residents from committing certain acts, for example, participation in terrorist acts or the provision or receiving of terrorist training. And then point B, it's about terrorist property. Now, you use the word any person instead. And then it comes with a footnote, footnote 8. Any person in Hong Kong. I don't know whether it's because Hong Kong is a financial center, and then you must put it in such a way so that the UNSCR will not criticize you. Any person in Hong Kong could mean a tourist. And according to Article 24 of the Basic Law, as the legal advisor said just now, a Hong Kong resident may mean permanent or non-permanent resident, but now any person covers such a wide scope. Any person, any transit passenger will be covered. So why is it that you don't put any person in point A as well? I haven't made up my mind yet, but let me give you another example. Let's say we have a lot of mainland tourists, foreign tourists, and we have Hong Kong permanent resident. Now, the say for foreign domestic helper or mainlander, they might have left the territory to join the IS on the strength of, say, a permit which they would return. And then, I don't know, the central authorities may give you another order, but it must come with reason. Anyway, in Hong Kong, if you're able to intercept them, from the UN's point of view, if you could just intercept one person more, then it would be better. And that is why, for somebody to be intercepted by Canada or Hong Kong, either way it is better. And also for Hong Kong, there are many flights. And then perhaps on the tip of an email, you can stop and intercept somebody at once. And then you can deport that person back to India. And that'll be the end of the matter. And if one leaves Hong Kong for Syria, however, for IS training and then for returning to India to perform a terrorist act, say ramming the truck into the crowd, then, like the legal advisor said, I think she's reminding you of the discrepancy. Will the scope be too wide? And it's a bit different. We must bear in mind that after reading your reply to the legal advisor's question, I have a question. That is paper 333, paragraph 3. In the end, you talked about difficult technical issues, and it is difficult to implement this, etc. If it's complicated technical issues and would give rise to enforcement problems, of course we should not directly copy from the UNSCR. Still, you're using any person and at the same time a permanent resident. You need to explain the difference. It's quite a technical question. You may wish to give me a written reply instead. I can give you a reply now, and I can also, as per Mr. James To's request, put it in writing. First of all, on the issue of financing such activities, we have used the term any person instead. It is important because, like Mr. James To said, we are an international financial center, and we know that for capital flow, it can be done with just a click of a button. We need to effectively plug this loophole. And at the same time, we have referred to the UN anti-terrorist provisions, Section 7. There is also a similar provision that is on financing terrorist activities. Again, the provision use the term any person. So on providing or collecting property to finance the terrorist activities, then I think we should use the same term any person, such that we can have a higher chance of stopping the person from traveling to between states for that purpose. Now, about leaving Hong Kong, why is it only confined to Hong Kong permanent residents, and what about others? It's not the case that we are only confining to Hong Kong permanent residents, but on the point of financing the travel of an individual for that purpose, etc., we need to make sure that any person will be subject to the prohibition clause. And for FATF, they've also provided guidelines on counter-terrorist financing. It is said that for combating terrorist financing, all should be involved. And we're also a member of the FATF, and we do have the obligation to follow the guidance. That explains the use of the term any person. Second point, Mr. James Toh asked about prohibiting any Hong Kong permanent resident from leaving Hong Kong for the purpose of, say, participating in the Holy War. And for a Hong Kong permanent resident or even other persons, you can still arrest them and you can just deport the persons who are not Hong Kong permanent residents. So we do have a mechanism to deal with an individual or a non-Hong Kong permanent resident. And also, there are ways to stop our effort, because we also attach great importance to human rights. Let's say at the time of deportation, the individual may file a torture claim. We have 80,000 such torture claimants in Hong Kong waiting to undergo the unified screening mechanism, and there may be room for these criminals to stay in Hong Kong for a long time. I'm suggesting that there is a possibility, which is already a headache for us. So we need to find other ways to effectively combat this. Let's say if a person from country X is locally born and raised in country X, and he so happens to pass by Hong Kong to commit such acts, then as soon as I inform country X of the matter, or maybe country X has more evidence on this individual, which could put this individual behind bars. So why is it that the United Nations have asked all the member states to implement UNSCR 2178? That is because we need to form a network. If we prevent our own nationals or permanent residents from leaving the territory, then these individuals won't be able to enter another territory. In some circumstances, as I mentioned just now, in the immigration ordinance, we may also bar entry of certain individuals. If we have intelligence that an individual may be suspected of participating in terrorist acts, then he may not be allowed to return, and in the case of a Hong Kong permanent resident, he will get arrested on returning to Hong Kong. From these perspectives, Chairman, we believe that our proposals in the bill are suitable. Mr. Toh, you may wish to ask further questions, but I understand that the legal advisor also has some questions to ask the administration, so you can perhaps take a break. Legal advisor, thank you. I think the focus is on the issue of Hong Kong permanent residents in 11 capital K, and on the use of terms, the administration has explained that this is in line with the UNSC's requirement. So, for the benefit of the members, perhaps the administration can also provide the resolution of the UNSC to us, at least in English version. It's not very long, so that we can refer to it. Because the resolution is not very long, it contains a number of decisions, and it's also included in the long title of the bill. We can look at the terminology in the resolution. And also, without clear definitions of certain terms, why has the government decided to include certain terms in the bill? And also, at the policy level, their consideration. As far as the law is concerned, has the administration sought advice from the Department of Justice, specifically on Articles 24 and 25 of the Basic Law, on the issue of permanent and non-permanent Hong Kong residents, how we can make sure that all Hong Kong residents shall be equal before the law, as in Article 25 of the Basic Law, including permanent and non-permanent residents of the Hong Kong SAR. Perhaps they should explain how, through the administration's interpretation of the UNSCR, they have come by the bill. Because for the letter from the administration dated the 3rd of November 2017, it seems that the administration has not explained in full the legal aspect of things, and members are familiar with some cases, Heisen, etc., and these may lead to criminal consequences, and if convicted, the individual may be imprisoned for a number of years. It is very serious. We need to make sure under what circumstances would someone be committing this offense. I have not said that there is no other mechanism to deal with other matters. We are looking at this bill, and we are considering the elements of the offenses in the bill. I think that they should provide the legal basis to explain the difference, the differential treatment, so as to help them achieve the legitimate aim. Mr. James Toh, I think that this is also helpful when we scrutinize the bill later. We need some information and supplementary papers from the administration. And the transfer panel is currently short of a number of members in the next room. But I'm not a member, right? But I am, and also Mr. Ray Chan. I think we can now pause for 10 minutes. We'll come back at 10:16, or the meeting will be aborted over there.